Welcome to Module 1, Week 8. I might note that these three modules in Week 8 are all shorter than they are in the first 7 weeks, and that's because you all have a final exam due this week and a case study. So we wanted to get you the information that's needed, but make it as painless as possible. So we have three topics here which are relatively straightforward. The first topic we have is incapacitated planning. And what does it mean? Well, it's defined as an inability to act on one's own behalf. And that could be because you're young as a child. It could be because of the fact that you're older and have some mental disorders like dementia. It could be that some people just have a lack of maturity, or that you just psychologically can't handle yourself. It's a very broad term, and it's meant when people need assistance. Is probably the best way to think about it. We have a very common method that's been around for many, many centuries, which is conservatorships and guardianships, where a court appoints someone to take care of your estate for you. If it's a guardianship, it's historically been the term for taking care of the individual, and conservatorship is for the assets of an individual. And that goes back, as I said, centuries, and that's why people under a conservatorship and guardianship are called a ward of the court. I might note that although you hear a lot about it, it's tend to not be used very much anymore because it's slow and very expensive, public, and very inflexible. Plus, if it's an individual who doesn't want to have the assets taken away from him, he's got to go to court and have the judge tell him that he is incompetent or she's incompetent to handle their own affairs. And that can be a very emotional, not only for the individual, but for the family. So I prefer, and if at all possible, stay away from this. The big advantage of this system, of course, using a guardianship or conservatorship you have is the court managing it. But again, that makes it very slow and expensive. Much more common is the power of attorney. It allows one to act as an agent of another. We have what's called a durable power of attorney, which can be used any time during lifetime, where a non-durable power of attorney is limited to the availability of principals. So if you're out of town or you're in the hospital, if you can't do the action, the non-durable power of attorney cannot act. That's why the durable is very important, because they can act when you are gone. I have used the durable power of attorney when I traveled internationally for business, and I found it a very useful tool. The problem with power of attorney is third parties are not required to acknowledge the power. So when I used it only with my brokerage, who I used their power of attorney form, and for my bank account, where I used the bank power of attorney form, realizing that probably no one else would recognize it. And again, I used their forms. And I would suggest that you think about using the forms of the organizations first, and therefore that means talking to the potential people who would be dealing with the power of attorney. But that certainly is a restriction on the use of a power of attorney. Springy trusts are very successful. The trustee has legal title, therefore everybody will deal with that individual because that's the only name they see, and that person has, for all intents and purposes, title to the third world. The trust takes effect upon some stated objective event or occurrence that's called out in the trust. That could be there's something that a doctor calls out, maybe two doctors, you enter a hospital, you get on an international air flight, whatever. And it also says when it's going to end. For example, you leave the hospital, you return from the flight. Duties of the trustee should be made very clear and complete. And the trust, as I said, ends on upon criteria set forth in the trust. Again, I've had people do these on their own. When I was in the business world, I had people who worked for me who did a lot of traveling, and some of them tried doing spring trust on their own, and they would forget things in there, or they'd make some big mistakes, and a lot of times the trust didn't work. So again, do not play around with this. There's a significant amount of money involved, and for many people on these things. So use the attorney. The attorney knows what they're doing and will accomplish your goals. Your power of attorney for health care. This is always a springing power, if that comes up on the CFP exam, and it's recognized in any state. Its power permits person to make medical decisions for the incapacitated person and access to medical records and can give permission to withhold or provide treatment. I think we've heard of cases for the last few years that made the newspapers on using these type of powers. I think also if you entered a hospital or your relatives entered a hospital, they had to sign these forms. If you have an attorney, he's probably or she has set up a durable power of attorney for healthcare for you so that you can have it to give to your doctors as well as the hospitals in your area. And of course, the attorney will keep a copy in case you lose your copy or you go to a hospital doctor that did not get a copy of it. Living wills are provided to give direction to allow one to die without use of further medical treatment. In other words, you're on the machines, and the only thing keeping you alive is the machine. Should we pull a plug or not? And this is not available in all states. That would surprise me when I first found out about it a few years ago, because I just assumed everybody had this, but no, they don't. So you have to check with the state you're dealing in to see if they have a living will. And again, that can be important for people. And you again should have the lawyer fill it out. Do not use standard forms that you get because again, you want to be very clear and your goals are met or your client's goals are met. Trust used for incapacity. There's 3 types we'll discuss: revocable trust, special needs trust, and Medicaid trust. Revocable living trust. A trust may be funded or unfunded. Again, funded means there's assets in it. Unfunded means at the current time there's no assets in it. The trust does require instructions for trustees. Again, and to have a trust, you really don't need any instructions for trustees, but as a practical matter, you really do. Unfunded is a standby trust with criteria as to when it takes effect and when the assets are transferred in. And again, the advantage or major advantage of a trust is the trustee has legal title so that the individuals can be taken care of. Special needs trust. This is taking special needs of a beneficiary. Typically when people have children who have handicap and they want to take care of them should anything happen to the parents. Trustees provide discretion over distribution of income with the goal of taking into consideration the special needs of the beneficiary. It avoids problems associated with assistance from public authorities, which is the big advantage of it, and will include a spendthrift clause. I note that a lot of times attorneys will be the trustees of these, and the court gets involved too. And where I've seen this most of the time is we're in court cases where a child is injured in an auto accident or in a hospital, and the payment is made to the child, and the judge sets up with the attorneys the need for some controls, and that's where the special needs trust comes in. The Medicaid trust, not a Medicare trust. The purpose of the trust is to remove assets from control of grantors who are eligible for Medicaid assistance without expending assets to a poverty level. It's an irrevocable trust that pays income only to the grantor and provides for additional evasion of corpus for special needs. Assets and trust created by applicant or spouse is treated as assets of the applicant. I might note that you should never get involved in writing these up. This must be done by an attorney. There's a lot of legal liability involved as to what happens, when it happens, where it happens, etc. And I would say that as a financial planner, Medicaid trust is something that you could discuss very philosophically with a client. And in the philosophical, it says basically is if there's Medicaid involved, we should be seeing an attorney. A convenience account, going back to the very first week, we talked about joint tenancy being multiple uses. It can be used for ownership of property. It can be also used as an assistance. And This is where it's used as an assistance. It's a joint bank account designated as a convenience account, and it's used to help incapacitated persons pay bills. It can also be used for other purposes similar. For example, I saw where one of my clients had one of these accounts set up. He was a very affluent attorney, and he had a sister who uh, made a lot of mistakes in her life. I guess the best way of describing it was more or less broke and had several children, and so he had her ability to get into his checking account as needed in order for her to pay bills come up. Well, as long as she didn't come up and take any money out of the account, there was no gifting. But when she took the money out of the account, it became a gift. I've also seen this used for people who are beyond the age of uh, making judgments for themselves and need people to help them to pay the taxes and to pay the utility bills, etc. So they have one of their kids or grandkids added to the checking account to do this. So the convenience account, I think, is something that most families are going to run into, either trying to help other family members who may have emergency needs, or use for family members who need help taking care of the bills or um, the normal day-to-day administrative things. With that, we've completed Module 1. As I said, these are relatively short, straightforward modules, and um, you should be familiar with them for the CFP exam. You should also be familiar with them for purposes of uh, your clients, because most clients will run into these type of problems, and you could be a good starting point. Again, on all of the things we talked about on this particular module, there should be an attorney involved, and without the attorney involvement, you probably are taking a big risk not only for your own professionals from being sued, but also for your client.